This is on working with IP clients, IP clients. I'm in the textbook, and in this section I want to just touch on a few topics that you read about. First off, when you have clients walking through the door, typically when we think of lawyers and interaction with clients, it's usually from the framework of somebody coming in with an issue and we help resolve that issue. In the case, for example, of, let's say this, if somebody is charged with a misdemeanor or with some type of criminal action, usually when they're coming to an attorney, it's for representation or what are my options at that point. So I think that one of the first things that we need to understand is that in the context of IP, the situation is often a little bit different because it's usually not so much of there are criminal procedures potentially that I may be facing, but rather nonetheless, there are legal ramifications of whatever course of action they take. So just like any other type of legal situation or where a client interfaces with a lawyer, the end goal is that they are trying to get some type of input on law. And that is exactly what is going on here. So when we sit down with our IP clients, they are relying upon us, upon you, to make sure that, one, you understand the law and that you can succinctly tell it in a way that they can actually understand. So with that in mind, let's talk about some of the similarities and differences of those clients that are coming through the door. I want to first break it down into different segments. One, I'll give you the normal perspective of clients that are walking through firm doors. And second, how that contrasts and differs and potentially some similarities of those that actually walk through the IP clinic. With respect to the first segment of those that are actually going to, let's say, a law firm, generally speaking, those that are going to law firms have one of two, I would say, criteria. One, that they can actually fund an attorney. So keep in mind, finding IP representation or representation to pursue their IP can be very expensive. And so if somebody is going to a law firm, there is a presumption that they in fact either have funds or have access to funds to be able to fund an attorney. On the patent side, keep in mind, the average going rate in the Bay Area, at least right now, is about $10,000 for just the legal representation. That doesn't include any of the government fees. On the trademark side, it differs between, on the low end, $1,000, high end, $3,000–$4,000 in order to get a trademark. So there is an assumption that somebody walking through the door actually has some money. I think one of the other big considerations is that for the most part, those that are going to the law firms usually are of a larger type entity status. And what I mean by that is that it's usually either on one hand a very global large company, and they are producing inventions and they protect those inventions as part of their normal corporate system flow. So if you went to my law firm, and we have many corporate clients that we provide services for. Every now and then you do get occasionally a smaller size type client, and by smaller size I mean anything from a solo type inventor or potentially, let's say, some type of a startup. One of the big issues with both of those sizes of entities is simply the fact that usually they don't have money. If it's a more solo type inventor, it's usually a garage type tinkerer or somebody that is trying to start a business on the side in their spare time. And in much the same way with a startup, one of the biggest issues that startups face is simply money. Do they have access to funds? And if they do have access to funds, who controls how it is the money is being spent? Can it even be spent on IP? So over the years, there's been a number of law firms that have surfaced that have tried to, I don't want to say market themselves, but they are definitely known for particular types of focus, whatever it is that they are providing to clients. And what I mean by that is, again, within the Bay Area, there's a few law firms that are known to target primarily to just startups. So their fee arrangement schedule is such where they often will take things on a contingency basis, where they say, if you come to us, we'll assist you with getting patents, and as part of that arrangement, we would get part equity in the company. So that's one type of an approach. You have other law firms that are simply known to provide provide services to large corporations. So, and I think one of the main conclusions from all this is that the larger the size of the entity, usually the more systematic they are in how it is that they approach IP. And not only that, but usually it's not their first time doing it. They usually have their own templates, their own patterns. And in fact, usually a corporation will not just employ one law firm to provide all their services. They often will have multiple law firms providing services, and they do that, one, to keep their own costs down, because if you have multiple law firms working for one corporation, they are all, in essence, in competition one against the other. And they're all trying to outperform the other and to outperform at a cheaper price than the other. So having multiple law firms all work for the same corporations from the corporate point of view makes sense, because it increases a little bit of the competition between the service providers. But that being said, again, the larger the size of the entity, usually the more systematic they are. And what that means is that when you're working with an inventor, they're coming before you, but more often than not, they have a company inventor disclosure form that they have filled out, that they've submitted through their own company channels. And by the time it hits your desk, meaning you, the attorney or the representative, it's already gone through a few layers of filters. Such that when it gets to you, usually it's a straight, brief phone call to touch base, make sure that you understand the invention, and then you do your work. The smaller the size of the entity, so the less, let's say, sophisticated, not that the small inventors are less sophisticated, but the less, I would say, traditionalists, or the less systematic in how it is that they are approaching, usually what that means is that we may have to spend a little bit more time working with our clients. And that's one of the reasons why it is that some law firms, in fact, do not even work with startups, or do not even work with small garage type inventors. One, the risk is too high as far as not even getting paid. And two, as far as time spent per hour, if they spend an hour working with one of these clients, they could have spent in that same hour on potentially multiple matters for a corporate type client. So from an efficiency point of view, it makes sense that if you're going to spend the money, spend it where it is that it is most efficient. And that's why a lot of law firms choose to focus primarily on large corporations. The other main reason is that it also provides a very steady income for the law firm. So when we look at the IP clinic, our focus is a little bit different. We provide services to anyone and everyone throughout the United States, and to a certain extent throughout the entire world. But that being said, most of the people that come before us are not of a corporate type mentality. They are usually those that are tinkering in the garage, or those that are starting up their own business. We've had everything from brands in Hawaii to Florida to patents, all the way from California all the way to Florida as well. We've literally have covered almost the entire United States. And most of these inventors and or business owners are this is typically speaking, their very first opportunity and experience working with a patent attorney or a patent agent. And so with that in mind, it is not your typical corporate type setting where they are simply going through the flow. This is for them usually a very first time experience, which is kind of fun because you also create a little bit of what it is that in their mind they will think of when they think of a law firm, or when they think of working with a patent representative or a trademark representative. So that's a great opportunity. It's also a little bit of a great responsibility, because how it is that you set the stage will often dictate what it is that they think and their opinions as to whether it was a good experience or not a good experience. So with these types of clients that are walking through the door, first off, I would say be a little patient. These are not necessarily people that understand the law. This is not necessarily people that even understand what is the very first step that I do here? These are people that, generally speaking, don't know where to begin, have a good idea, and they simply want legal assistance to make sure that their idea or their business is being protected. And that really is, I think, one of the great joys of what it is that we get to do. Working with corporate clients, great stability, great flow, great efficiency. My personal love, I love working with the small inventors. It's horrible as far as a pay structure is concerned, generally speaking, and it's horrible from an efficiency point of view because it simply takes me more time per hour to actually work with a smaller type, less sophisticated inventor or business owner. But the reason why I like doing it more is simply because they come with a greater passion and love for what it is that they are doing. So with a corporate client, generally speaking, the inventor says, I'm doing this, why? Because I'm being paid to. I've come up with a good idea, let's go through the flow. Let's get this legal stuff over as quickly as possible so that I can go back to do what I love doing, and that is just inventing within the corporation. The people that come before the clinic are a little bit different. This is their life. This is their hobby. This is something that they are very passionate about, that they have been dreaming, thinking, literally working on for the past probably 10 years. And they're sitting before you and they present to you this idea, concept, or business, and it literally is their baby. So treat it, one, with being very patient in how it is that you speak to our clients, but also recognize that just the gravity of the situation, this is something that is very dear to them. And we want to be careful if they come before us and they present the idea or the concept or the business, and we come back immediately and said, you know what, there's not even a way forward for you here. If it was in a corporate setting, that's just fine. They get that all the time. But for somebody that's coming before us, we want to be extremely sensitive to that. We want to, in fact, break the news to them, so to speak, much more gently. We want to say, you know what, based off of our findings, let's go back and we'll discuss them more. And we'll come back with a plan of attack for you. Worst case scenario, we can't take the case, but we will still outline what it is that you can do even if we cannot get involved. So you want to maintain a sense of hope, and we don't want to necessarily give them a false hope here, but my point is that we simply want to, if we have bad news, that we do want to break it to them gently, because for many of these inventors and small business owners, a lot is at stake. Their personal livelihood, as far as what it is they've been working on, is being presented to you, and we need to be respectful of that. I think one of the other main things that I want you to come away with is that the perspectives of those who are coming to us are often different than your perspective. And what I mean by that is the person, I worked in research for many years, and actually it was a fascinating time. I got to work on animal hair using a scanning electron microscope. And so I got to look at all these animal hairs from all over the world, literally from lemurs of Madagascar to the innards of the rainforest. And we're looking at how it is that hair could be used as a topology map to actually create, so to speak, an encyclopedia of animals. In other words, if you found a hair in the wild, can you even distinguish what type of animal it is? And one of the main focus of research is to be able to test, find conclusions, and then the focus is disseminate. You want to get the word out. You want to be able to publish. And in fact, for many professors, their livelihood as a professor depends on their ability to publish, to make things public, to get things out. And so the focus is very much on getting, concluding, and then pushing out. And many that come to our clinic are often under that type of mentality, where as a scientist or as a business owner, let's get the word out as quickly as possible. From an inventing point of view, I want everybody to know what it is that I've invented. From a business point of view, I want to get the word out, because the faster I get the word out, the faster I can actually make some money. But you, as the legal representative, need to keep in mind that your perspective is not one necessarily of scientific or business. Your perspective is legal. And what does that mean? That means that we need to make sure 100% that the legal foundation of protection is in place before there is any dissemination of the material. Now, on the trademark side, that's a little bit more loose. In fact, even for us to get involved on the trademark side, we require an in-use requirement, namely that their mark is being used or the name is being used in commerce in some manner. So as far as the dissemination there, that is fine. It's on the patent side in particular that we want to make sure things are proper and square before it is that they actually make it public. Now you may be saying, well, isn't there a grace period? And there is. Let's say that the inventor goes to a public fair and broadcasts what it is that they've invented. Good for them. But that public disclosure now is an official date, and they would need to get an official document on file before the U.S. Patent Office within a year's time frame. So yes, there is a 1 year's grace period, but my opinion is let's not even go into the grace period if we don't need to. And so when a client comes before you, and if it's relating to a patent, you need to make sure that the protection is in place before they go live with making it known. Because the moment that they go live with making it known, the reality is that a little bit of the cat is out of the bag at that point. And whatever is disclosed publicly, we need to make sure it is 100% met in whatever it is that we are actually filing on their behalf as well. So the perspectives here, in conclusion, are simply a little different. From the legal point of view, we want to make sure that everything is in place, the protection, at least, or I should say the potential protection, because protection is not granted until either the patent or trademark actually issues, but nonetheless, that the potential protection is in place so that they are adequately protected if they do go ahead and actually make it public. All right, now I have a few prompts, again, in the textbook that I indicate to you. So I indicate when starting a disclosure with your client, focus first on the similarities. And this is just simply when you're talking to the client, you want to make sure that you're building on what is already common ground. And obviously, if it's a more corporate client, you already have a little bit contextually to know what is the common ground, and you can work with that. But for those coming through the door, you want to make sure you understand where are they coming from, what is their frame of reference, is this their first time or is this their 10th time working with an attorney? Second, I indicate give a quick 30-second view as to why the disclosure process is important. And I do want to highlight one thing here, and that is the disclosure process, as we will also discuss in the next segment, the disclosure process is 110% important, because what in essence is going on here is a data download. You are receiving all the information from the client. Let's assume that there's 10 pivotal files that the client needs to provide to you, and they only provide you with 9 out of the 10. Well, 90% isn't bad, right? And I would say, well, if the 10% is the most important part of the entire disclosure, then the 90% almost was for naught. Because if we have failed to really understand what is important or what is novel or what is not obvious and what it is that they are providing to us, then to a certain extent we have failed. So the disclosure is really of the greatest importance, because that is the data download, where you get all the information from the inventor or from the small business owner. And once you have this database of all the information, you are then in a position to proceed forward on their behalf to determine legally whether or not they can proceed forward. So in short, if your foundation is faulty, no matter what analysis you do thereafter, it will also be faulty. So we need to make sure that the foundation is 100% spot on, so that when we then go ahead and invest further time and money as far as our time is concerned, that we make sure that that is not wasted time in any regard. Last but not least, state upfront your goal as a practitioner and provide solutions for any potential conflicts. And then these are conflicts as far as their goals and your goals, but it would also indicate that you also want to communicate that you will be 100% their advocate. That if a conflict comes up, that you need to, that's one of the reasons why there is a vetting process upfront to ensure that there are no conflicts as far as what it is that you are doing. And so with 100%, or what I should say, with no conflicts in place, then you are in a position to be 100% their advocate on their behalf.